I would like to welcome and introduce today's resource person, Advocate Mudit Singhvi. Mr. Singhvi is an advocate practicing currently in Rajasthan High Court and the District and Session Court, commercial courts, including forums. Mr. Singhvi graduated from Government Law College, Mumbai in 2014. In this duration, he has presided over various committees, including Model United Nations and Students for Promotion of International Law. He was conferred the Best Student Award in college and is an avid debater, specializing and taking part in more than 150 Model United Nations and national and international platforms, including Harvard, USA, and World MUN, and several parliamentary debates. He is a gold medalist in LLM and has specialization in civil, constitutional, commercial, and public international law. He is currently on the panels of various corporates, real estate, government departments, and urban planning bodies. He is an eloquent orator and engages frequently at discussions both contemporary and classic. We welcome you, sir.
Thank you so much. It's my pleasure.
Let me introduce you today's topic. The topic of this webinar is judicial activism. The judiciary plays an important role in upholding and promoting the rights of citizens in a country. The active role of the judiciary in upholding the rights of citizens and preserving the constitutional and legal system of the country is known as judicial activism. Judicial activism is seen as a success in liberalizing access to justice and giving relief to disadvantaged groups. Because of the efforts of Justice V.R. Krishna Iyer and Justice P.N. Bhagwati, there is growing dissatisfaction regarding the functioning of the executive and the legislature and their ability to deliver effective governance to meet the needs and challenges of our times. In the background of it is a matter of great satisfaction that the public at large continues to hold our judiciary in high esteem. The judiciary as custodians and watchdogs of the fundamental right of our people has discharged its responsibility very well indeed. The concept of the public interest litigation is always talked of when judicial activism is discussed. I would like to invite Honorable Vice Chancellor Professor Dr. H.L. Verma to welcome our distinguished resource person.
So thank you, Madam Alkananda. Now friends, first of all, I will like to welcome all the participants, including our keynote speaker, Mudit Singhvi, the faculty of the department, Sachin Kumar Goyal ji, who has recently joined and taken over as HOD of the Department of Law in this university. And dear students and all other participants. Now the Department of Law has taken initiative to organize this webinar on a subject which is highly important, significant to understand, not only for students of law, but for every citizen of this country, that what is judicial activism? What are its pros and cons? What are its different levels? To what extent it is desirable? And beyond that, where is the level it is not desirable to run the system? Now, in order to understand that, we need to understand India, India's democracy, the pillars of the democracy, the role of judiciary, and then the requirement for activism also. Now we all understand that India is the largest. It is generally said that India is the largest and most successful democracy in the world. In terms of population, we are second largest in the world. At present, it is estimated around 138 crores of people, population. We have our demographic advantages in the world. We are a young nation. We are the fast growing economy in the present situation. And India got freedom in 1947. And we adopted democracy as the concept of governance, forming government. Now it is considered that democracy is the best form of running the governments. And majority of the countries in the world today have democracy. So after independence, we adopted our own constitution. India's constitution is also considered as the largest written constitution in the world. Beautifully written constitution. So constitution gives us fundamental rights, fundamental duties, objective principles of state policy, and preamble of the constitution. It describes India as a sovereign, socialist, secular, democratic, and republic state. These are the 5 features that India is a sovereign state, secular form of government system, socialist philosophy, and we are democracy, democratic nation, and we are a republic. That is what our constitution has given. This form of government we have under the constitution. And then constitution preamble also states 4 values, 4 constitutional values which are intended to be achieved through governance, through the constitution. Now those values include justice, liberty, equality, and sovereignty. These are the 4 constitutional values. So preamble, which is a introductory statement given in the constitution, so that explains about the features of the form of governance under that constitution and the values which we intend to achieve through governance. Now, democracy is considered to have 4 pillars, basic pillars of democracy. So 4 pillars of democracy include legislative, executive, judiciary, and 4th one in the present times, that is the press and media. Now each pillar of democracy have its own functions, have its own role to play. Legislative part of democracy is concerned with framing laws, framing rules that the parliament at the central government level and the state legislatures at the states level are the legislative bodies the role of which is to frame laws. Then executive has to implement the laws. So we have executive system, we have the governments, the chief minister at the state level, ministers, and then bureaucracy. So which has to pass orders for the implementation of those laws. That is the role of the executive wing pillar. The third pillar is judiciary, the role of which is interpretation of those laws. To interpret that whether the orders which are issued by the executive, so those are within the framework and interpretation, and we have courts. We have a hierarchy that at the top level there is a Supreme Court of India, then high courts, then subordinate courts, and local bodies. So their role is that as judiciary to ensure that laws are properly interpreted and implemented in the country, and decisions are given. The fourth pillar, that is the press and media, their role is to inform, to bring into the knowledge of all people, all citizens of the country located at different locations, that what is happening in the country, how governance system is running, and to bring transparency into the system. Now, these are four pillars, and each pillar has a role to perform. Their functions are defined, their roles are defined. Now, this in a democracy, all these pillars, since they have their own roles, so there is a separation of functions. That is the concept which has been adopted by India, so that the system runs well. Now, if we have to understand this concept of separation of functions, we need to go back into the history. That before that democracy concept evolved and was accepted by the different nations in the world, so there used to be a kingship. So kingship was the system that when there used to be a king and was having all type of powers, including legislative, executive, judiciary powers, everything was concentrated at one place, that king. Now, since king was having all powers, then it was found that more power makes a person more, you can say, corrupt. So people, or the various philosophers who gave this idea of democracy, so they thought that there should be a division of power. That power should not lie with one person at one place. It should not be centralized. So then this democracy evolved. So basic concept of democracy is that all these functions should be separated. Now, different nations, even today, they have different political philosophy with which they are running the system. For example, US, that is based on the philosophy of separation of power, that this judiciary, legislative, executive, so their powers are separate and no one can interfere into the powers of the domain area of the other. So legislative cannot interfere into the executive powers and like that. So there is a complete separation. In UK, it is the rule of law. That is the concept, political philosophy which prevails. Now, when India formed its own constitution, so we adopted the middle path. That is separation of functions. That functions are separate, but in order to achieve objectives, some liberty has been given. Our constitution provides liberty that there are cases, there are areas where judiciary steps into the area of executive or legislative, and there are areas when it is otherwise also. So that liberty is given in order to effectively achieve the objectives of that particular functional area. Now, for example, the basic objective of judiciary is to deliver justice. In order to deliver that justice, there are laws, but at times situation comes that when law is not defined on a particular issue, law is not clear on a particular issue, so there is a freedom, some liberty is given to the judges that they can take decision in the best, with the objective of delivering justice based on their own personal judgments in the light of the public policy. Now, that is the area where this concept of judicial activism evolves. Now, for example, we find number of situations that when judiciary is giving decisions, so where those decisions as a common man we find should have been given by the executives. For example, on a Diwali day, if the court issues orders that there will be a ban on the, you can say, burning of these firecracks. No, it is a decision which actually should have come from the executive side. But court is giving in order to ensure that there is not an environment pollution, or you can say the already pollution situation is not aggravated. So sometimes they give the decision like that. There are many situations. For example, another example is given that when president issues an ordinance. Now, ordinance is a legislative function basically, and President of India is a executive authority. So executive, they are performing the legislative function by issuing the ordinance. Now, since Indian Constitution gives that authority, gives that liberty, that in order to achieve the objectives properly, effectively in a given situation, so there can be extension of the powers, extension in the functions performed by either judiciary or executive or legislative. So that is not illegal. That is not illegal, because our constitution has adopted a mixed approach. The mid path has been adopted in the constitution. But the point is that activism in certain situations we find is good, because ultimately the common man or the citizen is interested in justice. They want justice. And if justice comes from a judge and taking into account the public policy and other, you can say, situational things, if justice comes, that is good. So it means to some extent it is desirable. But beyond a point, it is not desirable. Because if all will start interfering into the territory of the others, executive will start interfering in the territory of judiciary, and judiciary will start interfering in the territory of legislative. So there will be a chaos. The democracy will be at risk. So it means to some extent it is desirable, as I understand, but beyond a limit it is undesirable, not desirable, because democracy must function properly. So we have to, as experts, we will like to listen from the experts also, that this judicial activism, what is its now present concerns, and we need to understand, because to understand law properly, so this is a very important concept, this judicial activism, that why it is desirable and beyond limit, where it is not desirable, how it should be exercised, what type of restraints need to be exercised. So that is basically the question is. So with this background, I once again welcome all of you and hope that it will be a great exercise today, and all of us will grow wiser with our understanding about our democracy and this judicial system and judicial activism. So I wish a great success for this webinar. So with these words, once again, welcome all of you and convey my thanks to the department for giving me this opportunity. Thank you. Thank you very much.
Thank you, sir, for sharing your precious knowledge and to grace this occasion. Now it is time to hear from our resource person. I would like to invite Advocate Mr. Mudit Singhvi to take over.
Thank you so much. May it please all. At the onset only, I would first like to thank the Honorable Vice Chancellor, sir, the HOD of the University Department of Law, the conveners of this webinar, as well as the faculty and staff for having me come and share my thoughts on a topic, as sir had rightly pointed out, as the Vice Chancellor sir has rightly stated. It's a topic that is not only of academic interest to lawyers, but is something which is actually touching and affecting the lives of every citizen of this nation. I would also at this point in time like to thank Senior Advocate Mr. Ashok Mehta, under whom I've had an opportunity to learn, and I'm still learning the practice and purpose of law and being a lawyer. Thank you all. Sir is the one who has also recommended my name to be, and because of which I am conversant with all of you today. In the course of my talk today, I would be dealing with what we mean by judicial activism. And I think Vice Chancellor sir has already given a wonderful, wonderful prologue and has made my task much, much easier because the nitty-gritties and the constitutional scheme, as well as the concept of separation of powers, has been brilliantly explained by sir, making my task very, very easy. So I will discuss about judicial activism, and eventually I will also make my observation on the quote which has come up on the posters for the program, which is whether our parliamentary democracy, whether our parliamentary system has actually simply failed to meet the challenges of judicial activism. That would rather be a remark, but whole and soul I would be dealing with what we actually mean by judicial activism. To start off, as sir has already elaborated the constitutional scheme, I would just want to reiterate and point out several things that that are fitted in the constitutional system that we are in today. As we all know, that the Constitution of India is often referred to as a mixed bag of borrowings, though uniquely suited to the Indian system, perfectly fitted together, in fact, I would say. The constitutional system that we are in, it envisages a parliamentary system which is based on the British Westminster model, and also a judicial system which is on the British pattern again. All of this has already been highlighted by the Vice Chancellor, sir. But if we do not read into the Constitution, but look into the powers that the judicial system or the judges actually have, including the power of judicial review, especially in the superior courts that we have in India, this is a power which has an American touch to it. So what I would want to reiterate and enunciate actually is that in various countries, so say for example, in Britain, you have the supremacy of parliament, right? In the United States, that is not the case. In India, you have the supremacy of the constitution and all the institutions of the constitution. So I would refer here to 3 and exclude media currently for the purposes of our discussion. The 3 institutions, and also media is not per se a constitutional institution, so to say. So the legislative, executive, and judiciary, and they have sort of, in the constitutional scheme itself, we have a separation of power therein. Now, this separation of power is so to say, for example, if we look at Articles 50 in the Constitution of India, etc., we can see that this is in fact a broad separation of power. However, we do have an inherent system of checks and balances, right? But in spite of having this sort of separation of power, the line is not very thick, I would say. And there's always an assertion, a tussle for assertion of power by various institutions of the Constitution. So even if we look otherwise at the constitutional scheme and look at the constitutional provisions that we have, let us for a second think about Chapter 3 of the Constitution, which talks about the fundamental rights. Now, this particular provision is something which is, again, you can say, borrowed from the West, originates in, say, for example, various of such rights originate and have references in the Bill of Rights, and also indirect references in the Magna Carta. This Chapter 3 talks about individual rights and liberties, or the fundamental rights, and a very specific provision in the Constitution, which is Article 32, makes these rights enforceable in the sense that anyone, any individual whose such rights which are fundamental to him are affected in any possible way or transgressed upon, then they can approach a court of law and seek redress. So this Article 32 is cardinal for the purpose of our discussion today, for the reason that the primary function of the judicial institution under the Constitution derives its power through this particular article, which empowers it to enforce the fundamental rights that are there in the constitutional scheme, which seem to be taken over from various other constitutions, and also on our own experience and understanding as to what should be the rights of a person who normally resides in this country. Now, another part of the Constitution, which is Chapter 4, is the directive principles of state policy. Now, this often and more or less talks about the social welfare or the welfarian policies. This is one part which has been borrowed from the Irish Constitution, and currently, or if not so currently, from the borrowings that ways, we can see that it has features of the erstwhile of erstwhile China and say Soviet Union. Now, these are welfarian policies, and however, if we look at the provisions for directive principles of state policy in the Constitution, we will find that the provisions state that these principles are fundamental in the governance of the nation. However, these are non-justiciable. So why am I discussing all of this is that while the fundamental rights are for the purpose of enforcement of individual rights, the directive principles of state policy are something which are required for the governance of the nation. The fundamental rights being justiciable, justice can be demanded by individuals in courts of law, thus giving the courts or that particular institution of the Constitution its power and purpose, which is to administer justice by ensuring that individuals are met with their rights, while the directive principles of state policy guide the other institution of the Constitution, which is the legislature, and even for that matter, the executive, formulate laws and policies which are more or less meant for the masses, right? And which are fundamental in the governance, keeping into mind those social welfarian principles. So while Part 3 of the Constitution provides the power and purpose to the courts, Part 4 drives the ambition or provides basically the context over which the legislature and the executive work. Now, even though our constitution doesn't per se categorizes and uses the word individual rights, or you cannot call it individualistic in character, nor can you call it socialistic per se in character. The use of these words, individual and social, is very limited in the constitution. It's not very explicit. However, we can see that in chapter 3, individual is the center. And for chapter 3, the enforcing agency is the courts. So courts will always be individual centric, while the legislative and the executive wings, or the legislative and the executive institutions or under the constitution, would always be welfarian based for the masses rather than having a focus over individuals. Now, when you are having institutions which are asked to make welfarian laws for the masses, it is often possible that they tend to ignore or per se pass over from the rights of individuals, because they have to keep in mind the welfare they have to have the welfare of the people in the backdrop while they are creating laws, policies, etc. And it is for this reason and the inherent sort of distribution of sort of even functions of the legislative and executive on one side and the judiciary on the other, that the need actually to intermingle these two concepts to come up with a homogeneous way of administering justice, because you will have laws which tend and support welfare of the masses, while people would always look for their enforcement of their inherent rights or their rights. So while the courts will favor individual rights per se, or their major role would be adjudication over individual rights, the laws shall be framed for the betterment of the nation on the whole. Now, it is for this reason that there has often been a dispute between the legislated laws and whether they sometimes transgress what we often call as the rights that a person has. Now, and these rights, mind you, will have to be enforced through these courts, these superior courts per se. Now, this stem, because of this inherent sort of position that our constitution sort of offers, there has to be, at some level or the other, some agency which introduces some creativity, and it is from this inherent sort of structure that we came up with the concept of judicial creativity, which started primarily from here. You know, why so? Because it was the primal need that rights, individual rights, were required to be read into these legislations. Or rather, I can also in other words say that some of these legislations which trumped over the rights of individuals were rather to be read down under these rights. So I will just repeat myself, which is that, there was a need, because of the constitutional scheme as we have, it was a need to be creative in a manner that we can read that, when the rights could be read into the legislations that we have from the legislature. And at times, we could read down the legislations under the rights that are provided to the individuals. Now, we all know, and especially anyone who has interest in legal philosophy would have definitely heard and gone through what we have had, a series of cases that we have had with regards to the framed laws and trumpeting of the fundamental rights. The cases of Golaknath, as well as Keshavanand Bharti case, which has been a landmark case, are known to all of us. But to give sort of an introduction and why am I discussing all of this here is that while the Golaknath decision, which came from a court of law, stated and sort of gave a transcendental position to the fundamental rights that they could not be touched by the executive, in the sense, by the legislature, which in the sense that the parliament cannot in a way disturb the fundamental rights provided under the constitution. It gave them a transcendental position by the reading of the constitutional itself. So there was a creative role which the judiciary started playing in, because it wanted to make sure that the rights are not transgressed by what the laws are made, and that the laws are also read harmoniously in a way that they promote social welfare, at the same time ensuring that individual freedoms remain. And it is from this sort of creativity that was needed in the pronouncements of the courts that the concept itself of judicial activism, in the sense that you are not only doing a review of the judicial decisions passed by the courts below, or sort of applying the laws already there into facts of the case, but you're also doing a purposive reading of the laws, or where you are supplanting the lacunae that exist in the laws to ensure the constitutional scheme itself, right? Not going beyond the constitution, but in ensuring that the constitutional scheme remains intact. When you do a purposive reading of the laws, or for that matter, even the constitution itself, to save its scheme, you are inducing a sort of creativity. And this creativity, as it was induced through various pronouncements, later on in its aggravated form, rather than being called a judicial creativity, was started being called as activism instead, right? So I was discussing that when there was a requirement that these individual rights be read into the laws that we have. A primal case with regards to that was Golaknath. And later on, the Keshwanand Bharti case said, even though the fundamental rights are not transcended, and the parliament does have the power to even amend these individual rights, however, no such amendment should be allowed, which goes against the constitutional scheme that we have agreed upon. Now, what is this constitutional scheme was something not clearly defined, leaving more scope of judicial creativity, which I might warn may sometimes or may at times result into adventurism, or even for that matter, call for judicial restraint in some cases. But it left the doors open, the creative doors open for the courts to decide as to what shall be the basic structure that we are talking about, which cannot be disturbed. So this in itself, now this is one such example of a judgment which by and large actually is spectacular, in the sense that no this sorts of creativity has ever been seen, that growing from the same institution, it protected its own powers to actually to actually protect the constitutional scheme. There may be arguments against the reasonings given in this judgment. In fact, this judgment itself was a 7:6 judgment. But such creativity started originating, I would say, from such judgments. Now, if I were to say and expand on this judicial creativity and the scheme of such judicial creativity that we started observing, the courts in the country, their jobs now remain not only review of judicial decisions, but they started even evaluating legislative actions and administrative actions. Now, I would further differentiate into the review of these legislative actions and administrative actions, because when we are discussing judicial activism, we would see how the trends emerged and the creativity of the courts started appearing in the landscape. Now, when you are talking about reviewing of judicial decisions, or for that matter, when the judiciary reviews the legislative actions, or even for that matter, the administrative actions of the executive, the usual provision that it uses, so if you're talking about the Supreme Court and when you're talking about the fundamental rights, is Article 32. So this power of review by the superior courts also emanates per se from this Article 32, and when it comes to the rights of persons. Now, this power under Article 32, when it is combined with the power under Article 141, which we often call as the precedent provision, or the provision which particularly states that whatever judgments are passed by the Supreme Court shall become binding over the country, over all the courts of the country. Now, this power of the precedent. So when Article 32 is combined with Article 141, this creates an sort of insurmountable power, which is given to the judiciary. And then the pronouncement, which have a binding effect, sort of get a legislated effect to them. And it is because of the joint reading of these two provisions that we have started calling such decisions as judge-made law. Even though the job of making the laws is of the legislative, these two provisions jointly read and the creativity infused, often these decisions can be termed as judge-made law. And this is where the judiciary has become active and in fact taken over the role as even the Vice Chancellor sir had pointed out in several cases. So say, for example, when the courts asked or imposed a ban over burning of crackers and other such instances, it has gone into the scope of, say, policy making, administrative decision making, and to top it all, legislating, right? So this is what we actually call as judicial activism. But activism in all senses has to be perceived in a very positive sense. I am not referring to judicial adventurism. When the activism is against the constitutional scheme, it may become adventurism with unpredicted results, or calling for restraint from the side of the judiciary. But when I'm using the term activism, I am implying that whatever is happening is for the cause of justice, right? And this activism is per se correct, more or less. Now, to trace down the history of this judicial creativity and its growth, we can say that, upon independence, the Supreme Court that we had with the limited number of judges was extremely conservative. There were new judges who were introduced into who were brought on board, and the membership or the number of judges was increased. But not until even 60s, the approach of the courts was extremely conservative in the sense that whatever legislations were available, they were doing a read as it is interpretation of those provisions and deciding the cases over legal aspects that or challenges that they brought in, right? But it was around in the 60s, specifically in 1964, when Justice Gajendra Gadkar became the Chief Justice of India. Now, he was called a very pro-labor sort of person, assumed to be one. And it was then that even in the welfarean labor legislations, or the labor legislations as they existed, based on the principles of state policy, he included in those legislated pieces a ray of hope for individual rights. How? So say, for example, in one of his celebrated judgments, he stated that when a laborer is terminated from service, it is warranted that an inquiry for misconduct be conducted first, and rather he not be terminated directly. So he tried to, in those welfarean laws or in those labor laws or laws for masses in general, he tried to bring in the concept of individual liberty by allowing or by stating that you cannot dismiss a laborer or terminate him from service just like that. It needs to appear to be well thought of and after a reasoning after making sure that there were reasons for such termination. So ensuring that the rights of natural or the natural and the principles of natural justice are not compromised. So he brought in an element of individual rights, even in the legislated laws. Now, this was an implied reading because the law per se did not provide for such a provision. But by incorporating such and by directing that an inquiry into the misconduct must be conducted, it was sort of the creativity of the Supreme Court, which enabled and ensured that the individual rights also remain intact in the legislated framework of the country. Now, I've already discussed that soon thereafter we had seen a tussle when slowly the Supreme Court also became more assertive in the sense that the conservative role was no longer existed, and they also had a proactive role. There was a time when the Parliament and the Supreme Court both were very assertive in the application of their powers. And it was that era which saw a tussle between the Parliament and the Supreme Court, and various cases such as that of the Golaknath and subsequently the Keshwanand, which we just discussed, were examples of judicial creativity and I would say judicial activism per se. Because that was when the courts had actually taken up an activist role, so to say. But most of all, it was in the 70s and 80s that which we call as the golden period of judicial activism and the growth of judicial activism per se. Now, this was because of the advent of public interest litigation. Several petitions, be it epistolary meaning that, petitions that were sent in the form of a postcard or a letter received by the judges of the Supreme Court were considered as potential cases. And the concept of locus, wherein the strict concept of locus, wherein a person would have to show and exhibit his cause of action and how he is affected or his rights are being affected to even appear and argue a matter before the court, was relaxed. And when the concept of locus was relaxed, the floodgates were opened to a lot of public interest litigation, in the sense that people who had a legitimate cause or understanding or even though not a direct influence by the cause agitated by them, they could approach the court and get suitable orders. Now, it was in this phase that the court actually even assumed the role of legislation, in the sense that its dictums and judgments were such that they helped the downtrodden, the outcasted, and various segments of the society which otherwise did not have access to justice, and for whom it was very difficult to show individual injury in order to get their individual rights enforced. So now in the garb of individual rights, even though a lot of welfarian judgments started coming out, and it was at this point in time that a welfarian role was also assumed by the courts in the country, which was essentially, as we discussed earlier, a prima causa of the legislature. Now, also what we consider as the very innovative and the sort of most innovative cases when we discuss judicial activism, we cannot but mention the Menika Gandhi versus the Union of India case. Now, prior to this was the A.K. Gopalan case. A.K. Gopalan was this versus the state of Madras, which basically talked about only the procedure established by law. And when that is adequate, in the sense that if you're talking about a violation of a fundamental right, if it is being done through a procedure established by law, that suffices. However, the Menika Gandhi versus the Union of India case, and this is when I come to, when I shift from judicial review, from the review of laws or judicial review of laws, legislations, I shift to judicial review of administrative actions as well. So it was in the case of Menika Gandhi versus Union of India, wherein they said, wherein the Supreme Court held that it is not enough that you follow the procedure that is established by law when it comes to individual rights, taking away of those, right? But it is also important that the procedure that you have already established is fair, and the actions of the administrative body or the executive are fair as well, in the sense that it's not enough for you to have a law or a set of rules to take away someone's fundamental rights, but you must ensure that whatever actions you are taking are also, and the act of the executive is also such that it is fair. So with this, inherently, did we start reading the due process clause into, say, for example, Article 21, which is the right to life and liberty. So this was for the first time that apart from procedure established by law, we also incorporated the concept of due process. So the courts now, through, again, their creativity, have started not only having a review of legislated actions or the actions of the legislature, but they have also started now reviewing the actions of the administration, which is the executive. So much so is the action which is basically so administrative in nature, right? So through this due process inclusion, what has eventually happened is that Article 21 has been given a broad interpretation, and this is where, when the judicially activist approach of the courts in the country have been most lauded, because as we discussed, it is and it has always been the primary job of the courts in the country to ensure that the fundamental rights or the individual rights, or that the individual always remains in the center and that his rights are never compromised, even though the state tries to ensure the welfare of the masses. So while the legislation would try in developing and growing the nation on the whole, the courts would ensure that the individual under this growth is never trampled or crushed upon. So the courts expanded the scope of Article 21, which is the article which talks about the right to life and liberty, and giving life a very, very broad meaning. They started saying in various of its judgments. So say, for example, the Francis Corelli judgment, which stated that life doesn't mean mere animal existence. And life, the concept of life under this article was extended to mean an existence which is decent, which is in an unpolluted environment, which is dignified, where you have the rights, where you are able to work to earn your livelihood in the sense that you lead a dignified life, etc. In fact, the court has started reading so many of such rights and principles into the already available such rights under the Constitution, that this approach is nothing less than supreme judicial creativity or activism, in the sense that even though we don't have a right to privacy, it is something which has creatively been read into Article 21. Now, this is the creativity or activist approach of the courts. Even though there are no legislations per se from the side of the legislative wing of the Constitution, even though there are no particular legislations per se which state or allow the right to privacy to be read into as one of the rights, or giving that even a legal status per se, directly, so to say, the courts have creatively read in the right to privacy under Article 21. Now, this has been discussed in the Rajagopal versus State of Tamil Nadu matter. Similarly, Article 21 has been broadened to include the right to livelihood. The Kapila Hingorani case included the right to food, access to food to those people who do not have access, in fact, to livelihood, means of livelihood. So thus incorporating the right to food. In fact, the Ramlila case, the Ramlila Maidan case included even the right to sleep as a part of Article 21. Now, all of this is nothing but judicial creativity, which is actually what we can call, in essence, as judicial activism. Now, we know that a host of such rights have been provided to the individuals by the courts and their decisions, which we call as judicial activism, be it the custodial rights, be it the right to live in a safe environment, right against atrocities, etc., etc. Now, these are not stated rights under various laws legislated by the parliament, nor are they rights directly incorporated as fundamental under the constitution. So, I would say that this is the sort of creativity that the courts in the country have shown. The recent examples, not very recent, but but rather laudable examples, have been when the Supreme Court has even has entered into administrative actions, in fact, and has ordered. So, say for example, providing helicopters to save lives of persons who are stranded in Uttarakhand, or for that matter, the cases such as that of Aruna Shanbag, wherein the courts talked about euthanasia and how passive euthanasia or the use or the euthanasia could be allowed in several cases. Also, a very, very creative approach of the courts has been when the laws have been silent over a particular issue. The best example of it could be taken as the case of state of Rajasthan versus Vishaka, the celebrated case which talks about sexual harassment of women at workplace. Now, the country had no legislation, in fact, to avoid or protect women from such kind of sexual harassment, or what happens in case if there is such sexual harassment of women at workplace. The court did not go all out alone in its own understanding, but actually, in order to be creative as well, it relied on the obligations that the executive of the country is committed to, in the sense that it referred to various international covenants, etc., and the international obligations that India has pledged to, in order to read and ensure that the rights of such women who are discriminated or harassed at the workplace, they do not suffer and their individual rights are not compromised. So it's in fact a reading of Article 21 only. And the court judgment, in fact, very particularly states that by the use of Article 32 and the use of Article 141, this now stands as a law in the country, in the sense that this is one of the best examples of a judge-made law. In fact, a law which remained in the legal sphere for a long, long time, till the legislature could actually legislate upon at the expiry of more than a decade or so. So, we have seen that the courts have assumed the role of creative, I wouldn't say interference per se, but creative indulgence into not only legislative actions, but also into what we call as now administrative actions. But as we discuss all of this and the growing assuming role of the courts in expanding the powers that it has, in its own understanding of expansion of its powers that it has tried to justify its action now through by using creative techniques again. While what is supposed to be used as a tool to ensure that lacuna in the legislated material be filled with, or that when it is actually required that, in laws which are welfarian in nature, individual rights may also be recognized, to ensure that the interpretation of the laws is only purposive, and while also ensuring that when we have committed in our international obligations to the world community, we cannot then not have laws or not have internal mechanisms to show that we are in fact committed to those principles that we are stating that we are committed to. For all of these reasons, if the judiciary in the nation has shown creativity. These are the some of the best examples of judicial activism that the country has shown. To sum it all, I would say that this creativity that the judiciary has shown, till the time it remains to ensure the constitutional scheme that we have in the country, to make sure that till the time the constitutional scheme does not get compromised, mind you, balance of power or separation of power also statedly being one of the features of the constitution. So till the time it doesn't transgress into complete assumption of the role of the legislation or the legislature, we can say that such sort of activism is in fact good, because it is only promoting individual rights, and that too not at the expense of the fundamental principles that are supposed to govern the country, which is the directive principles, so to say. So till the time there is a harmonization of part 4 and part 3, and such creativity is shown, be it in reviewing or supplanting it or providing decisions when it comes to review of legislative actions or review of administrative actions, that is fine till the time the constitutional scheme is safeguarded. But the moment assumption of the basic structure of that constitution, so to say, which again is a product of the creativity of the courts itself, we can say that the judicial activism would rather turn into adventurism. And adventurism of this sort has its own demerits, because it would then make the entire system of judiciary into a system whose results are unpredictable. There would, in such a scenario, predictability of judgments cannot be relied upon. And also the direct effect would be in the sense that the coherence of the system would be destroyed, because interpretation of laws, the moment it goes beyond the concept of constitutionalism, could become dicey in the sense that various judges could have their own interpretations, right? In the end, I would say that judicial activism, when the judges at the back of their mind understand that there is a need of judicial restraint to ensure the constitutional scheme in the country, shall be wonderful, because it will promote individual rights and at the same time ensures that any law which is for the promotion of welfarian principles in the country is not outlawed per se. Now, in the end, making a remark over the quote that is there on the poster for the webinar, which is that the parliamentary system has it failed? It has simply failed in living up to the expectations of judicial activism. I would say this is rather a very harsh statement, because if we discuss the constitutional scheme, the role of the legislature has always been such that it makes laws for the masses. And the role of the judiciary has been such that it ensures the individual rights of the persons. A bounded clash is supposed to occur, and it is only the enhancement or enforcement of the individual rights that the courts usually asserts its creativity to ensure the protection of those individual rights. So I would say that this use of judicial activism is rather to promote individual rights rather than, and on the other hand, the legislation, the legislative wing of the government is aimed at progressive welfare of the country. Since the aims and objectives of the legislation are different from what the envisaged role of the judiciary is, which is to ensure the individual rights, judicial activism is bounded to increase, and you cannot say, and you cannot per se say that the outcomes of judicial activism, the legislative wings has failed to accomplish, because it is meant to make laws for welfare of the country, right? So on this quote, I would like to thank all of you for so patiently hearing me out. I have given my interpretation and sort of reading of the constitutional scheme. Thank you so much. I would be happy, and if the organizers allow, if there are any questions or concerns, or even for that matter, comments, it would be wonderful to hear from all of you, if it is permitted in the session.
Thank you, Mr. Mudit Singhvi, for your well-versed wisdom. It's really very informative and intellectual speech. Thank you.
Thank you, ma'am.
Now I would like to introduce our head of the department, Dr. Sachin Kumar Goyal. Dr. Sachin Kumar Goyal has done his BA LLB honors from Aligarh Muslim University in Uttar Pradesh, LLM from GGS IP University, New Delhi, and his doctorate from Maharaja Ganga Singh University. Sir, I request you to take over.
Thank you, ma'am. First of all, our distinguished speaker, Mr. Mudit Singhvi, has given a uh, very good interpretation about judicial activism. I would also conclude him in this topic of judicial activism. Uh, First of all, we have to understand what is judicial activism. uh, uh, Judicial activism is something assertion of judiciary, and its power is referred to as judicial activism. It is also defined as an overactive judiciary. Few landmark cases that highlight judicial activism are Keshwanand Bharsi versus State of Kerala, Minerva Mills versus Union of India, Indira Gandhi versus Raj Narayan, and SP Gupta versus Union of India, etc. The active role of the Indian judiciary, particularly that of the Supreme Court, has been appreciated both within and outside India. The independence ensued through the constitutional provisions in favor of the judiciary and subsequently strengthened by the judicial interpretation has definitely contributed to the present status of the Indian judiciary. Yet, in this sphere of judicial activism, there are also a few coexisting misconceptions that need to be understood in order to appreciate the activist role of the judiciary in India better. Public interest litigation made judicial activism possible in India. Before the court accepts a matter for the adjudication, it must be satisfied that the person who approaches it has sufficient interest in the matter. The test is whether the petitioner has locus standi to maintain the action. This is intended to avoid unnecessary litigation. The legal doctrine that no one except the affected person can approach a court for a legal remedy was holding the field both in respect of private and public law adjudications until it was overthrown by the PIL wave. PIL, which is manifestation of judicial activism, has introduced a new dimension to judiciary's involvement in public administration. The issue of locus standi and the procedural complexities have taken a backseat in the causes brought before the courts through PIL. In the beginning, the PIL was confined only to improving the lot of the disadvantaged sections of the society, who by reason of their poverty and ignorance was unable to seek justice, and therefore any member of the society was permitted to file a case for appropriate directions. Golaknath case is also an example of judicial activism in that the Supreme Court, for the first time, by a majority of 6 against 5, despite the earlier holding that Parliament, in exercise of its constituent power, can amend any provision of the Constitution, declared that the fundamental rights, as enshrined in Part 3 of the Constitution, are immutable and so beyond the reach of the amendatory process. The declaration of law by the Supreme Court that Indian Parliament has no power to amend any of the provisions of Part 3 of the Constitution became the subject matter of very animated discussion. Keswanan Bharti had given a burial to the controversy of amendment of any of the provisions of the Constitution. By a majority of 7 against 6, the court held that under Article 368, Parliament has undoubted power to amend any provision in the Constitution, but the amendatory power does not extend to alter the basic structure of the Constitution. A criticism that we often hear about judicial activism is in the name of interpreting the provisions of the Constitution. The allegations are that judiciary very often rewrites them without explicitly stating so. In the process, some of the personal opinions of the judges metamorphose into legal principles and constitutional values. Another criticism is that, in the name of judicial activism, the theory of separation of power is overthrown and the judiciary is undermining the authority of the legislature and the executive by encroaching upon the spheres reserved for them. Now, uh, uh, I have a privilege to give a vote of thanks of this national webinar. I, Dr. Sachin Kumar Goyal, Head of the Department, Faculty of Law, Jagannath University, Jaipur, deem it a great honor to propose the vote of thanks to all who have helped us in making this webinar such a great success. First of all, I would like to thank our distinguished speaker, Mr. Mudit Singhvi, Advocate, Rajasthan High Court, Jaipur, for making excellent presentations and making this webinar interesting and meaningful. I would like to express our profound gratitude to our Honorable Pro-Chancellor, Professor V.K. Agrawal, and Honorable Vice-Chancellor, Professor H.L. Verma, for gracing today's webinar. I would also like to thank our respected Registrar, Tanmay Patnaik ji, for his support. I am happy to express vote of thanks to our faculty members and digital marketing team of Jagannath University, Jaipur, who have made this webinar a grand success. Finally, the wonderful students who have turned up in such great numbers, not only from our department, but also from other departments of the university, of our university and other university. Thank you so much for your cooperation. Thank you all.
Thank you everyone for making this webinar successful by being a